What's a default? Once a person has been served with the summons and petition, either in person or by way of the notice and acknowledgement of receipt, they have 30 days to file a response and pay the response filing fee. They can also apply for a fee waiver. If you, the petitioner, have applied for a fee waiver, it does not mean that the respondent gets a fee waiver. Each party has to apply for their own. If the other party fails to file a response in the 30 days, the petitioner can file a request to enter default. This is asking the court to allow the case to proceed because the respondent has failed to file a response. If it's granted, you are allowed to proceed to a judgment of dissolution without the other side being involved any more in the case. This is why it's important for you to have a third party serve the summons and complaint and file the proof of service, so the court knows the other side was served properly. A default usually will be granted if you're not asking for spousal support or if there is little or no property to be awarded. You may have to do what's called a default prove-up if there is property to be divided, meaning you have to appear in front of the judge and tell the judge what property is in the marriage, what you're asking for, and why it should be given to you. They're very complicated, and I would not suggest you do it on your own. You should probably speak to a lawyer first. As a respondent, being in default means you do nothing and the other side gets everything they've asked for in their petition. If you agree with what they've asked the court to do, then this is one way you may proceed. But if there is anything they are asking for that you disagree with, you need to respond to them and file a response. If the respondent has not answered, what does the petitioner do? Well, the first thing you as petitioner have to do is make sure you have filed a properly completed proof of service that shows the date the respondent was served and by whom, unless they've signed the notice and acknowledgement of receipt. You cannot get a default entered until you file the proof of service or the notice of acknowledgement and receipt first with the court. After you file the proof of service, you as the petitioner need to complete and fill out the request to enter default. It's Form FL 165. It's very important that you list the respondent's correct address in Section 3B on the form and that it matches exactly the address on a pre-addressed envelope, pre-stamped. You need to file the FL 165 with 2 copies and 2 envelopes that are pre-addressed and pre-stamped. One goes to you and one goes to the respondent. The clerk will review it and the case file to make sure you filed the proof of service properly. If all is in order, the clerk will then issue the default and send both of you copies. As the respondent, you have 30 days from the day you were served to file a response with the court. The response is a form that tells the court you agree or disagree with what the petitioner is asking for. You have to list the date of marriage, a date of separation, and any property that you think is community property. What is your separate property and how you want to handle the issue of spousal support. You need to pay a filing fee unless you apply for and receive a fee waiver, which is Form FW001, and that must be reviewed by a judge to decide if you qualify. After you file the response and a proof of service, you must serve it on the other party by mailing to their address of record or their attorney. You as the respondent then have to prepare and serve on the petitioner your preliminary declaration of disclosure, which includes your schedule of assets and debts and your current income and expense declaration with pay stubs or a profit and loss statement, unless you have Schedule Cs from the last federal and state tax filing you did. You also must comply with disclosing any material facts about assets, community assets, debts, and other business opportunities.